In your backgrounder, the best information that's available is the information from the state clearinghouse, is how many notices of exemption they receive, how many notices of preparation indicating there's going to be a new EIR coming out that they receive, number of notices of EIRs, of draft mitigated negative declarations, all those sorts of things. For the most part, not all of the categorical exemptions come to the state clearinghouse. We don't know how many don't, but it's probably the great majority are never submitted to the state clearinghouse. Mitigated negative declarations and negative declarations often aren't submitted to the state clearinghouse. They're not required to be in many cases. So we don't really know how many of those there are. So it could be that that 2% number we're looking at is actually even smaller. Because there are literally thousands and thousands of projects out there being considered by agencies every year, and there aren't thousands and thousands of CEQA lawsuits. The time frame for CEQA review, just ballpark estimates that we give to our clients, for example. If you're looking at a project that is categorically exempt, and assuming that you don't have to do any traffic analysis or biological surveys to ensure that this isn't going to have an impact on the environment, the time frame for that may be a week. It's very short. Statutory exemptions, depending on the complexity of the exemption, the time frame may be longer, could be in the neighborhood of months, because particularly infill exemptions that I mentioned that are hardly ever used, one reason they are hardly ever used is that they have a lot of different qualifiers. And so someone who wants to use it really needs to do studies of each one of the subjects that are covered by the qualifiers before they can determine whether or not this exemption actually applies to their project. So that one, matter of maybe a month or so. Negative declarations, we generally tell our clients that they're looking at about a 6-month period, again, depending on the complexity of the project. For environmental impact reports, we're looking at usually at least a year for any sort of project. For big projects, complicated projects, projects that will be controversial, it's more out in the neighborhood of a couple of years, 2-3 years, depending on the nature of the project. I worked on a project for a county who wanted to update their general plan. This is kind of on the far end of all of this. They had been working on that and the CEQA document for it for 10 years. The CEQA document had gone through 4 or 5 iterations before we were hired to finish up the job. So this can go on a very controversial, complex project for a very, very long time. Let's see, what else did I want to cover here? Yeah, I talked about exemptions. Those are very simple. The process for a negative declaration, just to run through it really quickly, the agency would prepare an initial study. They would do any other sorts of studies that might be necessary to determine whether or not there may be significance. They would put out a notice. And there's 3 different ways of doing that. Notice to the public and to other agencies that a draft of this initial study and this proposed negative declaration or mitigated negative declaration is now available for public review and comment. That would be available to the public or others who want to comment for at least a period of 20 days for projects that are of purely local concern, or 30 days for projects that involve state agencies or otherwise larger projects. The 30-day review periods also require that that notice be sent to the state clearinghouse. So those are the ones that go to the state clearinghouse. After the end of that period, then the agency is required to consider any comments that it may have received, and then if none of the comments indicate that there would be a significant unavoidable impact of this requiring an environmental impact report, they can move forward to consider the project and adopt it or not. After they do that, then they would adopt what's called a mitigation monitoring and reporting program. If there are mitigation measures, they would also adopt the mitigation measures in the mitigated negative declaration as conditions of approval of the project. After that, then, they're all done with this process, they've approved the project, let's say, they would file a notice of determination, and then as Professor Frank mentioned, that starts the statute of limitations. So you'd have a 30-day statute of limitations after the filing of that notice. If anyone wants to sue, they have to do within that period of time. One thing about the mitigated negative declaration, the negative declaration process, is that the determination as to whether or not to do an environmental impact report is something that is left to the agency and is subject to what is called the fair argument standard. And it essentially, if there's a fair argument made to the agency that the evidence that's on the record in front of them indicates that there may be a significant effect on the environment as a result of this project, they're required to do an environmental impact report. And so that's one of the key items that triggers environmental impact reports, this fair argument. By being a fair argument, it means that it doesn't necessarily have to be from any particular source. It could come in from anywhere. It could come from a member of the public who's an expert in a particular area and brings to the decision maker's attention this issue. It could be a competitor who brings forward an environmental issue. It could be the agency itself in the studies that it does. The agency may mischaracterize the study. That's been done in the past in some of the appellate court cases that you read. Agency mischaracterized its study, misinterpreted it, probably by accident. When you read it more carefully, it turns out the study's actually saying there may be a significant effect on the environment. That was held to be a fair argument. So this fair argument is a very powerful tool for forcing preparation of environmental impact reports on projects that would potentially have an impact. Don't have to prove that there's an impact, you just have to indicate that there's evidence there that there may be an impact. The evidence has to be factual. It can't simply be someone's opinion, someone's disagreement with the project, evidence that's clearly erroneous. None of that is a fair argument forcing an environmental impact report. It has to be expert opinion based on facts. So if I'm an expert, if I'm a pediatrician, for example, and I'm commenting on traffic, I'm not an expert. I may be an expert at caring for babies, but I'm not an expert on traffic. So it requires that there be expert opinion based on fact. Also, reasonable assumptions that can be made to support a fair argument have to be based on fact as well. And then, of course, facts themselves. So as long as it's one of those things, then it is one way that opponents of a project, for whatever reason, can force an agency to prepare an environmental impact report. It's in there as a safeguard. Because, as we mentioned, there's no CEQA police, there's no one who's making sure that agencies do CEQA when they're supposed to, and so this provides a means of the public or others, of other agencies, providing information to the lead agency so that they will recognize that they must do an environmental impact report in this case. An environmental impact report is our last thing. It starts off typically with an initial study, just like a mitigated negative declaration. Once the agency knows what the basic potential impacts might be, they'll send out for public review what's called a notice of preparation, or an NOP. NOP goes out for public review for a minimum of 30 days. It's also perhaps linked to a scoping meeting. In many cases, an agency will hold what's called a scoping meeting, again, to take public testimony or testimony from agencies about issues that may be of interest to them. Same thing with the notice of preparation. They're getting interest from various agencies, from members of the public, as to what might be issues to look at in their environmental impact report. Once that notice of preparation has been sent out, the agency will begin preparing a draft environmental impact report. It will be informed by the things that come in during the notice of preparation period. It will also be informed by other studies, air quality, traffic, et cetera, et cetera. Once the draft environmental impact report has been prepared, the agency will make that available for public review and provide public notice of that. Again, just like a mitigated or a negative declaration, two different levels of review. There's a 30-day review for projects that are solely of local interest, and then a 45-day review for projects that require state agency approval or of larger projects. Typically, almost no one does a 30-day review for an environmental impact report anymore. And even 45 days, again, if it's a controversial project, it's not unusual at all for the agencies to provide a much longer period for people to comment. 45-day review period for this draft environmental impact report. Review period ends. The public agency now must prepare a final environmental impact report. The final environmental impact report will include written responses to all the comments that were received on the draft, at least those that relate to environmental issues. It will also include the commenters' names and who commented. It will include the comment letters, which include emails and other sorts of correspondence. And then any changes that need to be made to the document in response to these comments. Sometimes the commenters point out clerical errors and other sorts of errors. There may be other reasons for the agency to bolster the administrative record, so they may add additional information at that point too. Once all of that is done, the final EIR will then be taken to the decision makers. They will review it and use it as the basis for the decision on whatever project it might be. Mitigation measures that apply to the project would need to be made conditions of approval or otherwise applied to the project unless infeasible. If the project has significant unavoidable impacts, The agency can nonetheless proceed with the project if it makes what's called a statement of overriding considerations as part of its findings. It also has to make a separate statement, a set of findings, indicating the disposition of each of the impacts that were identified in the environmental impact report. So if you have an impact on air quality, you have to disclose whether or not that's being mitigated, whether it can be mitigated fully so that it's no longer significant, or whether the mitigation is going to be the responsibility of another agency for each one of the impacts. So they would adopt both of those, a statement of override, set of findings, adopt mitigation and monitoring program indicating how those mitigation measures that are being adopted as part of the project will be implemented, and then I guess that's about it. Once they're done, once they have approved the project, they would then file a notice of determination, and the notice of determination kicks off this, again, 30-day statute of limitations for anyone who wants to sue the agency over the project. So that's the process. Some of the things that I guess we haven't touched on that are of importance to the CEQA process is that in the context of streamlining, CEQA over the years, as we mentioned, as Professor Frank mentioned, has been amended, particularly around nibbles around the edges. There are a variety of different streamlining methods that are in there. As I mentioned, there are streamlining exemptions for infill projects that hardly anyone uses because they're so complicated. There are also at least 5 or 6 different methods of what is called tiering, where you have an original environmental document that's been done, a negative declaration, mitigated negative declaration, or environmental impact report, and you're allowed to tier upon that or use that information as the basis for a later environmental analysis of a related or the same, some later aspect of the same project. So you don't have to redo things that have been done previously. You're simply looking at what's new with this later activity and analyzing what's new. As I mentioned, there's 5 or 6 different methods of doing that. Each one is unique. Each one has its own pluses and minuses, and there's probably a great deal of confusion over which to use when. Let's see what else. Yeah, it's really too complex to talk about that. We mentioned briefly, because each one, like I say, is different. Professor Frank briefly mentioned that enforcing CEQAs by litigation. There's a variety of different participants in the CEQA process, and what happens is that this broad standing that's available allows potential competitors to get involved. And in general, the courts have said that that's okay, provided that these people have some legitimate environmental concern that's been brought up. There's at least one Court of Appeal case where that was not the case, where the plaintiff lost the case because it was clear that they had only an economic interest involved. It involved I guess you'd call it a waste site, a waste disposal site, and a competing waste disposer brought suit, fighting this waste disposal site. But I guess they weren't clever enough, and they made it too obvious that they were in it for economic reasons, and the court tossed it out. They ended up losing. But that doesn't happen very often. In most cases, the plaintiffs bring up a variety of different environmental issues. They take part in the CEQA process, and so for all intents and purposes under current CEQA law, they're seen as having legitimate standing and moving forward. We mentioned already there's special rules for CEQA litigation. There's all kinds of claims that are made by the opponents of a project under CEQA. The typical ones are the adequacy of the analysis, the adequacy of mitigation, whether or not they've followed all of the procedures that are laid out. A typical CEQA case that at least gets to the Court of Appeal, because one of the things that I do for the Association of Environmental Professionals is write their, I guess it's quarterly, but it's only 3 times a year, maybe it's not quarterly, newsletter on CEQA litigation. So I follow the Court of Appeal and Supreme Court cases. Typically, it's a buckshot approach to CEQA. A plaintiff will throw everything they can at the agency, hoping that one of their claims will stick. So it's usually a pretty complicated sort of a case. And for someone who is not an attorney, such as myself, reading those cases, you wonder whether or not the courts are getting paid by the word or by the page, because they tend to be in the neighborhood of anywhere from 40 to 50 to 60 pages long. So there are a lot of issues that are brought up in a typical CEQA case, and there are a lot of issues for the courts to work their way through. So they're typically quite complex. Let's see, I have anything else? One thing to mention is that although we don't see many CEQA cases given the number of projects that there are every year in California, CEQA is by far and away the most popular approach to challenging local government decisions, particularly land use decisions. If you look at the number of cases that come before the appellate court that are actually published, those that will be holding precedent for other cases, there's anywhere between 25 and 30 of those every year that deal with CEQA. Almost every one of them is involved with some sort of a land use project. Some of them, you know, you have one like the plastic bag case where they were going after an ordinance limiting plastic bags, not really affecting a land use project. But far and away, most of them relate to some particular land use project or some particular land use plan that's being proposed. And it's the most popular way of challenging these things. If you look at how many other cases there are challenging land use plans or land use projects that don't involve CEQA, almost none. Maybe one or two here and there each year. So it's by far and away the most popular way of doing that. And I think that's one reason why it has the high profile it does, is that those are the cases that people bring forward as the, you know, either the horror stories or the stories that indicate how CEQA saved the world. It's those land use cases that stick out. And with that, I've done with my testimony or my discussion here. If you have any questions, I'm open.
Well, thank you very much. Senator Jackson, you have a question?
Yes, that last comment begs the question, why CEQA, and are there other options available in challenging land use, and why is CEQA the most popular one?
Yeah, there are other opportunities for challenging, but CEQA is the most popular one because it has the broad standing, and also because of the complexity and procedural complexity of the CEQA process and the CEQA documents that are prepared. An agency is more open to challenge on CEQA than it would be because the courts tend to give deference to the agencies when they're making other sorts of decisions, and perhaps less deference to the agencies when they're making CEQA decisions. For example, the fair argument, when the fair argument is raised over a mitigated negative declaration or negative declaration, the courts don't give deference to the agency over whether or not the agency's determination that there was a fair argument existed. They will leave it open to themselves to decide whether or not there's a fair argument based on the evidence that's there in the record. They're not going to recalculate the air quality.
So if we were going to try to tweak this, would you suggest that the courts should have that ability to effectively second guess? Do you think that that's in terms of the goals of CEQA, do you feel that that's an appropriate responsibility of the courts, or do you think that they shouldn't have, or at least we should set a higher standard so that they can't necessarily overturn the agency?
Yeah, you're asking a non-attorney, non-litigator this sort of question. So, but nonetheless, yeah, I would say not to fool with that much. It would be my recommendation because CEQA is very complex, and one of the things about CEQA is that there's a lot of uncertainty. And I think if you give the courts too much additional movement in there, that just creates more uncertainty as to what the outcomes may be.
My suggestion is, would you recommend giving them less movement? In other words, that they would be required.
That would be very difficult, I think, to get through the legislature. You know better than I, but
well, I can't pretend to know whether through the legislature. I'm looking at just ways that we might.
That would be one way, certainly.
Yeah, the CEQA process.
That would be one way, certainly. But historically, the fair argument has been one of the sacred cows of CEQA. Okay. And I think that anything that would go about limiting the application of the fair argument would be very, very difficult to pass, in my opinion.
But my question really isn't a political one. It's really a
but it would certainly help, right?
And help in expediting it, or help?
It would help in expediting. If your aim is to expedite the CEQA process, to reduce its complexity, then that would be something that would be helpful. Yeah. If your aim, on the other hand, were to ensure that agencies are held to account on the CEQA process, perhaps not then.
And I'm going to ask this question. I always hesitate. I'm a recovering lawyer, and you're not supposed to ask a question to which you don't know the answer. But I'm going to go ahead because I'm not wearing my lawyer hat as a member of the legislature. In your experience, and I'm very impressed, by the way, that you say you're not a lawyer, because the complexity of what you've just shared with us, I think has some of us, and I am a lawyer, with our eyes sort of crossing at how complicated this whole process is. Not that it's bad, it's just complicated. After all is said and done, do you believe that at the end of the day, the result, after going through this intense CEQA process, has benefited the people of California?
It's a difficult answer, a difficult thing to answer. I think that overall it has benefited California, sure, because over the years we've gotten better projects. The projects that come in are simply better than they used to be. And developers, agencies, I think they're looking for better projects than they were before. It also helps integrate into the decision-making process all these other things we have. As Professor Frank mentioned, it's multi-topical. And so air quality, traffic, biology, cultural resources, all of these things are brought together so that the agencies have a broad view of what the impacts of this project might be, rather than just relying on other agencies to issue their permits and everything will be fine and dandy. The decision makers have a good idea of what the project's impacts might be, what other agencies are going to be involved, what other permits may be necessary. All of that comes together as part of the CEQA process. So I think that, yeah, it's better than it could be. On the other hand, there is...
That's okay, no further questions.
Okay, there's the parallax view. And some...
yourself to be a lawyer.
Yeah, and some would say that to a certain extent, CEQA has led to the urbanization of the Central Valley, let's say. When you look at who are the people who are most litigatory with regards to CEQA, it tends to be people on the coast. Who are those most welcoming of projects? Who are those who litigate the least? Who of those have perhaps the least public interest in projects? Perhaps not so much anymore, but historically tend to be the Central Valley. So do you end up with, because it's difficult to develop in, say, the Bay Area, and easy to develop in, say, Modesto, development moving to Modesto because it's just not quite as long a period to get your permits, a little more certainty, all of that sort of thing. There's no evidence for this actually occurring. Right. Right. And the land is cheaper and all of that sort of thing. Right. But there is that parallax view that you hear now and again that perhaps over the years, CEQA has contributed to some of the sprawl that we have. The other thing is, too, CEQA looks at infill projects, unless you're exempt, looks at infill projects and greenfield projects identically. Even though you're proposing an infill project, you don't necessarily get a break on your CEQA process. And so, because infill has a lot of neighbors who may be opposed to the project, the greenfield may not have any neighbors at all. Again, this parallax view of CEQA contributing to sprawl.